be seated. You may resume.
May it please the court, Your Honor. Thank you. I think when we took our lunch break, we have been kind of going through a chronology of what was going on at the time, and we were really now at the point where you have watched the video and we are talking about the moment when that door begins to open.
Yes, sir.
And I think we had talked about the distance between them at that point in time is a short distance.
Yes, sir.
And then you had explained why that video sometimes differs slightly from what an officer's perception is.
Correct.
One of the things I want to ask about an officer's perception, are there ways in which officers are typically instructed to take a view of somebody they're confronting?
Well, from a threat assessment standpoint, we mean to take a view proxemics-wise, like stand in relation to them. You want to,
and also threat assessment in terms of what they look to first.
right. So it can be in many things. They say hands kill. So a lot of times you're going to direct your attention to the hands to see if they're possessing any weapons. The other thing is, and I think familiar with or consistent with this case, was you're looking at their facial expressions. You're looking for the manner in which they're approaching you, and you're going to assess that. And where your attention is first drawn is going to dictate that. If they have a mean look on their face, you're probably going to notice that and then start doing the other. If they're calm, you might just calmly look at them and then start doing threat assessments or risk assessments.
And in the video, at the time that door begins to open, the officer has not unholstered his gun, for lack of a better term.
Right.
Is that consistent with the way you would have expected an officer under the circumstances to proceed?
Right, based on what he had at that was not inconsistent. I wouldn't have expected him to draw a gun at that point. The fact that he didn't surprise me.
And you are present, you are watching it, and excuse me, you are watching when he is presented with the gun in the hand of the Mr. Fortson, correct?
Correct.
What was the reaction that was typical with the training for a circumstance just like that? He's confronted about 4 feet away from a man who has a gun in his hand at the door.
Yeah, so.
Yeah, I'm going to object to relevance and refer back to my motion in limine in terms of him ultimately giving his opinion as to whether the defendant is guilty or not.
A reserve ruling.
Yeah, so keep in mind, we talked about earlier when he knocked on the door and announced himself and said he's the police. The relevance of that now is that once you've identified yourself, you've set context. And we've set context, everything you interpret is then based on the context you set, right? So the easy example of that is if you see somebody suddenly reach behind their back, but they're at a register at a quick shop or 7-Eleven, that is movement consistent with grabbing a wallet. The context of that movement is how an officer is then trained to interpret it, to train to consider the following things, right? In this sense, in this case, the context was set. Well, I'll give you one more example. If you tell somebody not to move and they move, you can infer certain things than if they move and you hadn't told them not to. This is why police are trained to set context through which then they can interpret that scene. In this case, when you ask me, was that consistent? Because he had knocked, because he had announced, he's going to now interpret that scene consistent with the context he reasonably believes he set. Now, whether he's actually said it or not, we've talked about it's his perspective I'm worried about here, right? Does he believe he set a context? Now, when that guy comes to the door with a gun in the context of an officer, I know or I reasonably believe I'm responding to a violent domestic. I reasonably believe there might be somebody else in the house who might need my assistance. I knocked and announced my presence, so now I reasonably believe
Action-reaction.
Yes, sir.
Does action-reaction training, does it play a part in the kind of decision that he was faced with at that point?
Right. I mean, the window can't be tighter or smaller than a situation that he was confronted with, meaning he has to do something right now to immediately and decisively stop the threat. And that window, and he has to do that before he's actually assaulted, before the harm actually occurs. So the window is the unknown time between the threat of harm and the actual harm. And we don't know what that is. And so when he's perceiving that threat from a response time gap, there's no way you can tell what that response time actually is, but you reasonably believe that if I don't do something right now, if I wait for a further assault, then the window has slammed shut for me to be able to do anything at all.
Does the law require, does training require, or the law suggest that you have to wait till the gun's pointed directly at you?
Your Honor, I'm going to object, and again, this is an explicit question as to the law and the witness commenting on the applicable law instead of the court.
A reserve ruling.
Yeah, we certainly have not seen, nor have I conducted training where an officer would wait or be instructed to wait until somebody pointed a gun at them when conducting an imminent threat. I would add, if that happens, it is evidence, if you have a scale, what we're looking for in the case is any rock we could put on one side or the other. If they do point the gun at you, it certainly is a rock on the side of intent, right? But the absence of that pointing of gun certainly doesn't negate all the other circumstantial evidence of intent that the officer might already have. And so, to your question, I guess the answer is yes, right?
And did you, upon the analysis that you just shared with the court, did you report back to the sheriff's office your findings as it related to this particular instruction that he had given you to look at this case?
Your Honor, I would object to relevance as to his findings and conversations with the sheriff's office. It has nothing to do with what the court or the jury will ultimately find.
Reserve ruling.
So can you repeat the question? I want to tighten
Did you report back? You've given us an analysis that you, I'm sorry.
Hold on just a
Does
second.
it say? Yes, ma'am.
You sure you use that microphone, Mr. Alderman?
Oh, I'm
I
sorry.
think that's the court reporter telling us you're not speaking into the microphone, so slide it over next to you so we make a good record, okay?
Yes, ma'am, I will. Yes, Your Honor. The court reporter says, Mr. Alderman, you were speaking over the mic, and she couldn't make a clear record.
Oh, gotcha. Okay. Thank you.
Sorry for the interruption.
No,
The
I've done the same.
great new digital world.
I've done the same thing. I think, to go back to the question I was going to be repeating anyway, you have shared your analysis on the training and the correctness of the decisions that were made under the circumstances and the context.
Right.
What I want to know is, did you, because you had been assigned to look at this by the sheriff, correct?
Correct.
Did you report back your opinions to the sheriff and his command staff as requested?
In that meeting, our focus, the short answer is yes, I did share my opinion, but the surrounding conversation where we spent time was in each step of the imminent threat analysis, much as we're doing here, and showing what evidence was consistent with. There wasn't a need to debate whether he posed an imminent threat under the operational requirements of an imminent threat. Intent, ability, means, opportunity. We focused our attention on the additional requirement. Their policy is more restrictive than what we typically, well, it's more restrictive than any law I've seen or policy. It's more restrictive than the constitutional standard as I understood it. And so our focus of that conversation wasn't really about whether he posed an operational imminent threat. It was about whether
Did you have any objection to the idea that this did present, the circumstance of the man answering the door with a gun in his hand presented an imminent threat to an officer?
Clearly, he did.
Go ahead. Now, there was an issue, I want you to explain, there was some difference here among whether or not something additional was required.
Sure. Their policy requires.
Your Honor, I'm going to reject to questions in reference to the sheriff's office policy.
I'll reserve ruling.
Sure, their policy required what I believe it said a hostile, and attacking movement, which was identified shorthand as an overt act, right? An overt act, in addition to the imminent threat, he had to present an overt act. The conversation simply surrounded that a agency policy can be more restrictive than the law. An agency policy can be more restrictive than constitutional and the statute. But that doesn't change the reasonableness analysis. It just changes the policy approach. The example I would give today is if a sheriff wants to say you can only shoot people that have red shoes, if the person otherwise poses an imminent threat of death or serious bodily injury and they're not wearing red shoes and you shoot them anyway, that certainly is a policy violation, but it would not affect the reasonableness application. So from a police practice and policy writing standpoint, one of the things we're constantly clear on is policy does not equate standing alone to reasonableness, because all the considerations that go into policy development go far beyond just simple reasonableness analysis. There are political balancing tests, there's financial balancing tests, there's resource balancing tests, there's training balancing tests. That's what makes up your policy. So if a sheriff wants to be more restrictive for any of those reasons, they certainly can be. And violating that would be a policy violation. But it does not necessarily affect the reasonableness analysis. That's what was the bulk of the conversations.
And tell us how you responded to the idea that you need some sort of overt act.
Well, in addition to the otherwise imminent threat requirements, you also had to have an overt act. I just simply said that the reality of that, I try not to be flippant. We don't see that anywhere else. I wanted to make that clear. This is unique to your policy. But beyond that, we just focused on the human performance aspects. If in fact you intended this restriction, then the operational consequences of that is you're requiring the officers to get shot first. Because the speed with which that person will initiate that final overt act is much faster than any human can respond to it if it's done at the speed of, speed of an assault. Typically, I mean, they can miss, obviously, so there's things. But we focus then on, if that's intentionally the policy, that you want to add that on top of the otherwise imminent threat analysis, then you're going to have to focus on evasion or focus on medical care, because you should reasonably anticipate your deputies are going to be getting shot more frequently because they're not allowed to respond to the imminent threat absent this final policy restriction.
Were you asked some other questions in which you gave opinions regarding some suggesting that the door, if you did it behind closed doors as opposed to the open door, anything like that?
Yeah, when we were discussing the overt act requirement, it was my impression that the overt act had occurred.
I'm sorry, I don't mean to interrupt, but I objected earlier, and I don't know if the court considers that a standing objection to this entire line of argument, or if you want me to keep objecting every time.
You make your record as you feel is necessary
Yes.
to be preserved.
Yes, Your Honor. Well, I would object for both relevance and, again, the existing or the policy implications as it pertains to the finder of fact.
Reserve ruling.
Yes, sir.
Go ahead.
Yeah, so as the discussion surrounded the overt act requirement, I started to try to give examples of how operationally that was a distinction without meaning. And because the overt act occurred, it just occurred behind a closed door. And so I tried to give examples of, had he opened the door, saw the police, and then grabbed a gun off the counter, would we also have then required him to raise the gun? And of course, let me stop there. I want to say what the answer to that was. In my opinion, it changed nothing, right? Had they entered the house and he was working the domestic and he sees the female and he sees the male of any domestic, and the guy leaves the room and comes back with a gun to his side, the context of that exact same movement, that exact same approach to the officer would have changed nothing that occurred at the door, because the officer believed he was investigating a domestic, he believed he had been identified. The door comes open and he sees a man standing with a gun. The question is it reasonable for him to believe he has the apparent intent, ability, means, and opportunity to inflict death or serious bodily injury? In other words, did you grab the gun to place me in reasonable apprehension of bodily harm or death? And if the answer to that was yes, it's reasonable to believe that, whether that's actually true or not, I'm analyzing it through the perspective of the officer. Would you agree that you didn't also then require him to point and shoot the gun or point the gun at you? And so I tried to give examples of how there was no distinction between what actually occurred and these other examples where nobody was going to contest that, yeah, if the guy leaves the room and comes back with a gun, he's an imminent threat of death or serious bodily injury. It would be reasonable in that context for the officer to believe that. That was, again, the crux of where those discussions went.
And do you find, in the context of someone who, in the light of what the facts are that you knew in this case that were presented to you by the provided to you by the Sheriff's Department, do you believe that the context was such that when he opened that door and displayed a gun, that was an imminent threat?
Again, I'm going to object for relevance. I'm going to object for referring to inadmissible self-serving hearsay. I'm going to object as to bolstering. I'm also going to object as to establishing witness credibility.
Reserve ruling.
Did you find that to be an imminent threat?
Yeah, I'm going to be careful here again, because the way I continue to phrase this is, could an officer in that position have reasonably believed this guy posed an imminent threat? And I did not think that was a close question. My answer was yes. An officer in this position, and you have to make certain assumptions that he believed that he was identified as the police, that he reasonably believed that he reasonably believed it was a violent domestic, that he reasonably believed he had set the context, and then the man opens the door with a gun in his hand, then yes, it was my opinion that a reasonable officer could have believed he posed a threat of death or serious bodily injury, and that our training would have reflected that.
And was his response to that imminent threat consistent with the training that he has received as a law enforcement officer in Okaloosa County?
Your Honor, I'm going to object for relevance, I'm going to object for bolstering and referring to inadmissible self-serving hearsay.
Reserve ruling.
Yeah, I'll have to be careful here. He wasn't part of the training I witnessed, in fairness. I don't know
You
what
mean
his...
he wasn't personally part of
He
it?
wasn't personally part of it. The imminent threat analysis that we just discussed was reflected in their actual training. And there was no requirement in their actual training for this overt act piece. So we presented that, so if he received the same training or consistent training with what we observed, then the answer is yes.
And did you based on all that you've talked about before, have you formulated an opinion as to whether or not the reaction by the deputy under the facts of this case was reasonable in light of all that you've told the court?
Your Honor, I'm going to object for relevance, I'm going to object for referring to inadmissible self-serving hearsay and bolstering.
Reserve ruling.
Can you repeat that, please, sir?
Yes. In light of what you've already told this court, did you find that his reaction to be reasonable in light of the imminent threat that was presented?
Okay. Yes.
And did you tell the sheriff's office that, including the sheriff?
Your Honor, I'm going to object for relevance.
Reserve ruling.
Yes.
Just a few more questions. It has been suggested, or might be suggested, that because Florida is a carry case, state, that a person has the right to arm themselves in their own apartment.
Correct.
You agree with that?
Yes.
Consistent with that, then how do you explain your findings in this case that this was a justifiable and reasonable act?
Your Honor, I'm going to object to referring to inadmissible self-serving hearsay and bolstering.
Reserve ruling.
Yeah, it goes to the testimony earlier about setting the context. So if I'm already in your house, in some contexts, you can certainly have a gun in your house and carry it in your hand if you want. When the police are present investigating a potential violent felony or violent domestic offense or dangerous offense, and then you arm yourself, if the circumstances are consistent with an intent to place you in apprehension of serious bodily injury or death, that then becomes a crime, and crimes occur in people's houses all the time. Otherwise, innocent behavior can be used to conduct crime. For example, as I was thinking about trying to come up with a good example, I can drive my car down the highway, I have every right to do that at 35 miles an hour, or down the road at 35 miles an hour. But when somebody stands in front of the car with a stop sign, a police officer stands in front with a stop sign, and you do that exact same legal conduct, the context with which you do it is what makes it illegal, not the driving of the car itself.
It might have been suggested that Deputy Duran should have waited longer before deciding to shoot his gun. How do you react to that?
Your Honor, I'm going to object. I don't even know what we're talking about here. I don't know if he's referring to online comments suggested by who, so I don't know the relevance of this
Lack
question.
of foundation.
I'm sorry?
Right.
Yes, so I don't know sort of the...
I'll rephrase.
All right.
Did you see any evidence that would have suggested that the officer's action was too soon or premature?
Yeah, I'm going to object for referring to self-serving hearsay and bolstering.
Reserve ruling.
So in any time we're looking at these cases, we're looking at the second question, Your Honor, which is, was the threat assessment reasonable? The second question is, was the response to that threat reasonable? And in cases of deadly threats, the typical response that's trained is a response of deadly force. And so to the degree we would evaluate, Could they have otherwise evaded? Could they have run? Could they have tried less lethal? Could they have continued efforts at de-escalation or persuasion? All of those are tactical choices, all with risk, benefits, and trade-offs. And so if we were talking in our discussions about whether he could have gotten off the X, right? You're standing there in a danger zone, you're on the X, that's where you're most dangerous, and it's like, why couldn't he have just run? Well, my first question is to look at the jurisdiction, see if it's a duty to retreat state or not, and I'll let them determine that, let the court determine that. And then the second thing is, from an operational standpoint, the risk, benefits, and trade-offs. The trade-offs is there's somebody who he reasonably believes is injured in the house, he's now abandoning, right? There's a myth that running and turning your back from an armed suspect, if you believe you're running, my question was, what are you running from? Well, the guy with the gun, who you reasonably pose a threat of death or serious bodily injury, or you wouldn't be running, is one of the interpretations. Running and turning your back certainly doesn't create a safer environment for you. And we see this frequently in traffic stops where the officer will turn and run instead, or try to draw, turn and run. And we've done research repeatedly where the driver just shoots them in the back instead, right? So the idea of turning and running and creating space in a situation like this where he only had one avenue to run, and it wasn't much of an avenue to run to get, because apparently he was blocked in, he couldn't go one side, there was a rail. But he could have gone back the same avenue he had approached. You're just exposing your back, and that's not a safer position to be in. The final question was the window of response is dictated by the speed of the assault, the potential speed of the assault, which you don't know what it's going to be, but officers are trained to consider that it's going to be faster than you can recognize it's even happening. The speed of that assault, you can see various ranges of that speed. I've personally seen those at 1/10 of a second. So I don't need research to show me. I've seen case after case where 1/4 of a second, 1/10 of a second, where that gun already in their hand comes up and fires. That's the amount of time, that's the window of time the officer has to respond. So running, trying to outdraw it, if that intent is to fire the gun, that window is already closed. Response time window.
Just a few further questions that I omitted earlier. You were retained by the Sheriff's Department, correct?
Yes, sir.
My office did not retain your services, is that correct?
Correct.
Now, after your deposition was taken and you were disclosed as a witness, have you charged my office for your services? Or are you going to charge it one way or the other?
We are going to charge you, yes.
And do you know what your rate of charge for your services are?
It's $600 an hour for consults, it's $4,000 a day for testimony, it's $2,000 a day for travel and standby days. The travel days is really standby days because I can't work on other things.
And the only amount that I have paid for has been the time since after your deposition was taken.
For the deposition itself?
And the deposition and afterwards.
I would take your word, you paid for it. I have, our CFO looks at that.
Okay. Just very briefly. I think you said it earlier, but when you finished your analysis, did you find this to be a difficult case to analyze or come up with an opinion on?
Your Honor, I'm going to object. Again, this refers back to the same objections I've made before, plus this is now bolstering his own opinion.
All reserve.
I'll be careful because I do understand somebody passed away in this. So in terms of is it difficult, to the degree this was his actual intent is unknown. I didn't think that part was easy to watch. But in terms of the legal analysis and the operational realities of everything I saw was consistent with police practices and training and the law as I understand it, and it was not even a close case from a legal standpoint.
Just one moment, Your Honor.
Mr. Alderman.
Good afternoon, sir.
Good afternoon, sir.
Mr. Smith just asked you about the financial matters. Are you going to I assume you're going to send them a bill for today, correct?
Yes, sir.
Okay. You're not billing the state for today, correct?
The state? No,
Yes.
sir.
I know you went through your background earlier. In terms of your time as a police officer, it was around 15 years, is that correct?
Full-time was closer to 10, and then I stayed on as a reserve. So when I went active duty military, I continued to work as a civilian cop on weekends and holidays for many years later. So a total of, I think 2018 is when my commission expired. So from 93 to 2018, with some breaks in there for military.
Okay. So 25 years with some breaks here?
Roughly, yes, sir.
Okay. Now, sir, you've repeatedly referred to this case as a domestic violence case, correct?
The investigation of it was, yes, sir.
And you're aware, I'm sure, that the information that was conveyed to Deputy Duran at the time did not indicate a domestic violence scenario, correct?
The information he had at the time
Yes.
was that there was a disturbance in the house and that the witness believed it was getting handsy. I think the shorthand for that, I think it was described on dispatch as a disturbance. And so, yeah, I think the fact that it was in an apartment, I may have characterized it as domestic, but it was a disturbance that was getting handsy, is how I think he understood it.
Right, but it wasn't described as domestic, was it?
I don't know that it was, no.
And you're aware there's a big difference between domestic violence and other types of violence, correct?
Right, but I would say also that one of the witnesses said she had thought she'd heard a male and a woman arguing earlier and that there was a slap. So to your point is, what was he investigating? My understanding was that was one of the things being investigated based on the total information. But yes, if you're going to investigate just a disturbance and you know it's a disturbance between, say at a bar or at a parking lot versus in somebody's apartment complex where you might reasonably infer it's a relationship there, those would be different events.
Okay, so my question was, domestic violence is very different than other types of violence, and it sounds like your answer is yes. Is that fair?
It can be, yeah.
Okay.
Yeah.
And you would know that. You've had a lot of experience with domestic violence, correct?
Yes, sir.
Okay. And I believe part of your master's thesis was dealing with domestic violence. Is that right?
It was.
Would you agree that the information that Eddie Duran has as he's approaching the door and standing at the door and making these decisions is critical?
Yes.
Okay. And information that he does not have and that he's learned after the fact is really not relevant?
To his threat assessment response, yes.
Right. I mean, he can only make decisions and analyze on the information he's received, correct?
Yes, sir.
And so it's important to be important about what he knows and does not know, correct?
I would push back just on the word "know" because in the investigation, you know very little. You're just getting information for leads to investigate. So is it important for him to discern what he reasonably suspects, what he reasonably believes, and what he knows? I think those are critical distinctions, yes.
Okay. And information that is learned after the fact is obviously he can't know in that moment, correct?
Correct.
Okay. Now, one of the things you said earlier was that you considered important was the duration of the argument, and that this was a long, ongoing argument.
Yes, sir.
Okay. Are you aware that Eddie Duran was not provided any information about the duration of the argument?
I don't recall right now what they relayed in that regard, so I can't say that he was aware of that now.
Okay, but you're making an analysis, in essence saying he made the right decision. It's important for you to know what he knew, correct, in that moment in time?
Yeah, what he reasonably believed. Yeah, if he was aware of that information, that would be important, and if he wasn't, that would also be important, yeah.
Okay. But wouldn't that be important for you to know in determining the appropriateness of his decision?
It'd be one factor, sure, yeah.
Okay. You discussed with Mr. Smith that first knock and sort of the pros and cons of announcing, not announcing. Obviously, one of the disadvantages of not knocking is that it's very difficult for the person to know that there's a police officer at the door, correct?
Correct.
And in a setup like this, where there's an apartment, there are no windows, and the person cannot view the parking lot, it becomes that much more difficult for the occupant to know there's a police officer at the door, correct?
Correct.
And the officer that's doing that knocking should be aware of that, correct?
Correct.
And in terms of knocking and announcing, there's really no way for the deputy to know what's being heard inside the residence, correct?
Correct.
Okay. He doesn't know what the people are doing, correct?
Correct.
He doesn't know where they are.
Correct.
He doesn't know if they have headphones on.
Correct.
He doesn't know if they're hard of hearing.
Right.
Okay. And he's aware of all that as he's knocking, or should be aware of that.
Correct.
Okay. One comment you made about the body camera is, I don't want to mischaracterize you, but your words were you can't assume that what is on the body cam, that the officer sees everything, correct?
Correct.
That he may be paying attention to other things. It's hard to know what he knows, correct?
Correct.
Okay. But that same analysis would apply to a deputy as he's knocking on a door, that he doesn't know what the person's doing in the residence or paying attention to. Right?
Correct.
And he can knock as loudly and as many times as he wants, does not mean the person is aware of what's going on, correct?
Correct.
You talked about the action-reaction and how quick that can happen very quickly, right?
Correct.
So in a situation like this, if Roger had decided to fire his gun, he would have been able to shoot Eddie Duran before Eddie Duran responded, correct?
Correct.
Okay. And your opinion would be that he would be able to fire off multiple rounds while Eddie Duran's still trying to draw his gun, correct?
Correct.
And I think in one of your, in some of the information you provided to me, I think it was about 6 or 7 shots, would you estimate?
Yeah, if we're doing an average trigger cycle at about a quarter of a second per cycle, the amount of times it would take if the officer was drawn, I think the animation was 1.5 seconds or maybe 1.7 seconds to get it out of the holster and get your first shot off. You're going to take a quarter of a second, and how many times that goes into 1.7 seconds, that's how many shots can potentially be fired before the officer got his first round off.
So in this case, you believe Roger could have fired 6 or maybe 7 shots before Eddie Duran was able to return fire?
Potentially, yes.
Okay. But obviously he did not attempt to do that, did he?
Correct.
You talked about a couple of examples with Mr. Smith. You gave the example of if somebody comes to the door, opens the door, sees a police officer, and then goes to grab a gun, you believe that that's similar to this situation?
Correct. What the distinction was, if they reasonably believed it was the police at the door, there's no distinction between the two. That's my testimony.
Okay. But obviously a person opening the door and seeing the police officer the police officer knows that that person can see them, correct?
Correct.
And there's no doubt at that point that the person knows it's a police officer.
Right. And that's
Well,
one.
hold on, let me get to my next question.
Yeah.
So if then the person is grabbing a gun, the officer knows they are now grabbing a gun with the knowledge of police officers at the door, correct?
Correct.
And you gave a similar example about the room. If the officer was in the house, person leaves the room, comes back with a gun.
Correct.
Again, the officer knows that the person has seen him, correct?
Correct.
Seen him wearing a uniform,
Correct.
knows he's law enforcement,
Correct.
and is now grabbing a gun after seeing law enforcement.
Correct.
I think you said the only difference here was the closed door, right?
Correct.
I mean, you'd agree you can't see it through a closed door, correct?
Correct.
Okay. And so part of your analysis was that you believe that he knew that there was a police officer at his door, correct?
No, that's not my testimony. My testimony is whether it was reasonable for the officer to believe that he knew after knocking and announcing. So I have no idea what he knew, what he actually knew. And my testimony was that the officer is responding to the context as he sees the context, and he's interpreting behavior in that context. So the question was whether the officer knocks and announces if it's reasonable for him to believe that the person coming to the door who heard the knock also knows it was the police, because those things happen simultaneously, knock and an identification before he came. So to the degree the officer reasonably believed that he'd been identified by the police, as the police, that's the context with which everything else was being interpreted. And to your point, it's a very important addition. Had the door open and he also visually saw it, not just heard that it was the police, but visually saw it, that's another large rock on the side of intent.
So your position is that Eddie Duran had a reasonable belief based on, in part, based on the things he said, correct?
Based on what was on the video and yeah, correct, the things he said that as I saw him on the video, right?
Well, and he said that he heard the word police, correct?
Yes, I don't think I testified to that. It hasn't come up yet, but yes,
But that was part of your analysis, correct?
correct.
So, and that led to your belief that he had a reasonable belief that the occupant was aware the police were there, correct?
Yeah, and again, I'm gonna do the scale analysis. Those are two big rocks on the side of yes, one that he announced himself and two, he heard him say police, so yes.
So, but the information for that is his statement, right, about police?
I'm sorry, the officer's statement?
Mr. Duran's statement.
Well, yeah, partly from the video and partly his interpretation of what he heard, correct.
And you got that from his interview with Internal Affairs, correct?
Right, his statement.
But there were other statements in the Internal Affairs report, correct?
Certainly.
Okay. From Ms. Hendricks?
You'll have to refresh me on what the statement was.
She was on the phone with Roger at the time?
Okay,
Now, in that report, she clearly states that there was no speak of police, that he never said police.
oh, the lady on the computer?
Yes,
Okay, yes,
so you're aware of that.
yes,
But your position is that he reasonably believed that somebody said police inside.
he being the officer?
He being Eddie Duran.
Correct.
Okay. Did you consider the testimony of Ms. Hendricks?
Yeah, if you want, I'm talking about the perspective of the officer at the scene and analyzing to their perspective, not other witnesses. So if you're trying to say that he never heard that because no other witnesses heard that, I don't know that to be the case. He can certainly hear things that other witnesses didn't hear, and that's a focus of attention issue. Certainly, it would bolster it, and the fact that she was unable to bolster it, saying, I didn't also hear that, is some evidence I'd put on the board as relevant, for sure. But we don't expect multiple witnesses based on what they're paying attention to, their focus of attention, even on a camera, whether the mic would even pick up something like that. I don't know where that occurred at. I'm assuming he was talking to her when he said it. So it's going to be a credibility determination. If that's your point, that's absolutely valid.
Okay, and you made a credibility determination about those statements, correct?
No, if I haven't been clear, I don't have to make credibility determinations. My things are based on assumptions of the facts that we're seeing in the record. So if the officer reasonably perceived that he said police, that goes on the side of the officer's perception. If he later finds out that's not what was said, it's about apparent intent, it's about reasonable belief. We later frequently will compare an officer or a witness's perception of an event with forensic evidence. In almost every single case, forensic evidence may be inconsistent with the individual people's experience of that event. That's very consistent. So if you're basically describing to me, he perceived the word police, but the forensic evidence later said it was another word, that would not be unusual. So I'm not actually saying I believe him and not her. I'm saying if that's his reasonable perspective, that's going to set the context for his decision making. If other witnesses didn't hear it, they didn't hear it.
But when he says he perceives the word police, you accept that at face value, correct?
I accept that he reported he heard the word police.
Okay. Do you consider the possibility that he's lying?
Yeah, that's always goes on the board. In every case, every statement by a witness or an officer that's inconsistent with other forensic evidence, you can just say one reason for that may be that they're lying. And then you list the other 10 reasons why those inconsistencies might also exist.
You did not reach that conclusion in this case, did you?
No, I couldn't. That would be beyond anybody's ability who is evaluating a case to determine who's lying and who's telling the truth. I'm evaluating it from the lens of the officer's perspective, his reported, what he heard, what he perceived, what it meant to him. The credibility determinations, none of us are in a, well, I'm certainly not in a position to make those.
But you are when you're making a determination based on his perceptions that he's telling you, right? You are making that determination.
No, again, these are about reasonable beliefs. If you're telling me that he reasonably believed he heard the word police, that's going to be relevant. And I'm telling you, if that's what he perceived, then his threat assessment, the context he set from police and the fact he announced himself are relevant to the imminent threat analysis. And if those things are true, then a reasonable officer could have believed this guy posed an imminent threat of death or serious bodily injury.
Right, so you believed it was true in making your ultimate determination, correct?
I don't do credibility determinations. It's beyond none of us can do that. So you asked me, could I put on the board he's lying? If you came to me tomorrow and said, we now have evidence he's admitted to lying about it, I go, okay. But if you have that evidence, then I would certainly, there's nothing I have that you don't have in this case that tells me that him lying about this event, I'm not doing a credibility determination on the officer.
So you would need evidence that he's lying.
If you're going to tell me that I should not consider his perception that they said police is accurate because you have evidence he's lying, of course I would receive that evidence and then consider that and evaluate the case without that rock on that side.
And you'd said earlier about the perceptions with the body cam, you rely on the witness statements, correct?
Yeah, we're required to reevaluate
correct,
the
sir?
case. Okay, rephrase it, I'm sorry.
No, I
Please.
don't need to rephrase it. Is that correct?
I-
You said you rely on the witness statements, correct?
Over the body cam?
You said that you can't assume what somebody sees or hears in the body cam. You rely on the witness statements, correct?
Right, the witness statements about their perception. I rely on their statements about what they perceived and what it meant to them over what I see on a body cam, correct? Because I don't know that they saw anything on the body cam that I'm witnessing.
And that's what you did in this case, correct?
Correct.
And similarly, you mentioned his facial expressions. That was, or Roger's facial expressions, I'm sorry. That was, again, going back to the defendant's statement about what he observed, correct?
Right.
You mentioned, when Mr. Smith was asking about the distance and the gap, and you said that 4 to 6 feet, I think was, obviously, he had the ability to use that firearm and kill him at 4 to 6 feet, correct?
Correct.
Would he have had that same ability at 8 feet
Correct.
or 10 feet?
Correct.
Okay. So is it fair that that distance is more important with, say, a different type of weapon, say a knife?
Correct.
Okay. With a firearm, whether it's 4 feet or 20 feet, the person still poses an imminent threat of great bodily harm, correct?
Right, to a limit. I mean, we got to start worrying about accuracy issues, but
Right.
yes, you're exactly right. With a firearm, you can have a pretty decent standoff distance and still pose an imminent threat of death or serious bodily injury.
So in this case, would your analysis have changed at all if he had been, say, 10 feet away?
No.
Okay. And I think you had talked briefly earlier about the policy, and that an agency is sort of basically free to dictate whatever policy they feel is necessary, regardless of their policy can be more restrictive than the law, correct?
It can be more restrictive, correct?
More restrictive, yes, sir. And as a lawyer, the difference between policy violations and, criminal intent, or what we're here for today, are two very different things, correct?
Agreed.
Okay. All right, thank you, sir.
Read your act.
May it please the court. You were asked, and let me go back. I don't believe I asked you during your direct examination, did I, as to any particular statement being overheard?
Correct.
But you saw in the records, and you were asked about, and you were even suggested that perhaps that somebody might be lying. You saw evidence that there had been an analysis by the department, done by FDLE and provided to the department, which corroborated the idea that a statement had been made. Whatever that statement was, that a statement had been made.
Your Honor, I would object. This goes back to I think it's my fourth motion in limine as to the enhanced audio that FTLE did.
I'll reserve ruling.
Yes, sir.
I am aware that they did an enhanced audio that corroborated that a statement was made and that the word police was suggested in that.
You were asked a couple of questions about how long the dispute was. What you know is that Ms. Sims provided information to a Ms. Rodriguez who provided information, and even when she waited and actually talked to him and explained what was going on as she walked towards the scene with him, correct?
Correct.
Ms. Rodriguez.
Correct.
And you were asked some serious questions that I want to make sure I'm clear on this. Let's assume for a moment that you do not hear what we heard by the enhancement. Assume that doesn't exist for just a moment for my purposes.
Yes, sir.
From the officer's perception, when he gives the announcement, repeats the announcement, and the door opens thereafter, almost immediately after the second announcement with his name, with his identification as a
Right.
deputy sheriff, right?
Correct.
Okay. That alone, does that tell you that the officer would be reasonable in assuming that someone heard not only the knock, because they've answered the door, but they heard the knock and the announcement that accompanied the knock?
Right.
Your Honor, I would object to the speculation.
Reserve ruling.
So, Your Honor, when we are analyzing this in police practices and what reasonable inferences can be drawn, we use a concept called anomalies and baselines. Baselines are something that police do frequently. Police knock and announce frequently, and the reaction of the occupants is consistent with awareness of the police presence based on that knocking and announcing. If there are anomalies from that, somebody wearing the headphones, which I believe I testified to earlier as well, you're not aware of the anomalies until you become aware of the anomalies. And so you have to make a baseline assessment that when I knock and announce, the baseline is that they understand it's the police because you so frequently see that and see behavior consistent with that recognition. So I would add that there could be anomalies that make it so that the person didn't actually recognize them as the police, but from the police perspective side of that, that would be an anomaly off the baseline.
A couple of more things. You were asked about, I think you said 10 feet, would it change your analysis? And you said no, it wouldn't, correct?
Right.
What is, however, in terms of the threat itself of being shot, the closer you are, how close you are increase the likelihood of hitting their target?
It would.
And is that why that there are rules for close engagement that are somewhat different than from farther away?
It depends on how far away. There's not a meaningful distinction between 6 and 10 feet as was presented, operationally or tactically.
It was suggested that somehow that he did not fire, he meaning the man who has the gun.
Right.
You've done, the research has been done on this, something called counter ambush, et cetera. What I'd ask you about is, does the law require, does the best practices that you wait until such time as the gun is fired before you react?
Your Honor, I would object to, I would say this calls for a legal conclusion.
I'll reserve ruling.
Yeah, from the perspective of training officers in response to a firearm threat, the answer is no. I've never seen or participated in training where an agency would require that the officer wait until somebody pointed the gun at them or fired the gun before responding to the threat.
Thank you.
Is the witness released?
Yes.
Yes, Your Honor, from the state.
Yes, Your Honor.
All right, thank you very much. Good day. Your next witness, please.
Peter Hernandez, Your Honor.
All right, Hernandez, please.
No, actually, you've been released.
Sir, I appreciate you giving me a chance to object before you answer questions.
He
just asked, no, he's released. Yeah. So you can talk, you can do it, but you can't talk to somebody that testify. Okay.
Yeah, let's, you want to maybe approach?
Granted.
Five, 389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Sorry. If you raise your right hand for me, please, Madam Clerk, swear to witness.
You swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Please be seated. Direct your voice to the microphone you see there in front of you. Speak clearly and distinctly so we can all hear and understand what you have to say, and the court reporter is able to make a good record. Is that okay?
Yes, sir.
If one of these lawyers object, stop speaking until you receive an instruction on how to proceed. Is that okay?
Yes, sir.
All right.
Thank you, Your Honor. If you could, please identify yourself for the record,
I am Detective Peter Hernandez of the Orange County Sheriff's Office.
and can you go ahead and spell that for us?
I'm sorry, say again?
Can you spell that for us?
Yes, sir. Peter, Peter, last name Hernandez, Hernandez.
And can you describe your current roles with the Orange County Sheriff's Office and the Florida Department of Law Enforcement Task Force?
Yes, sir. I'm assigned to the Florida Department of Law Enforcement Electronic Surveillance Support Team full-time. I oversee the audio-video enhancements lab.
And is that for all the audio and video enhancements that the FDLE does statewide?
Yes, sir.
Okay. And you do that, but you're also employed by the Orange County Sheriff's Office. Is that correct?
That is correct.
And what is your capacity at the Sheriff's Office?
I am a detective.
Okay. And how long have you been with the Orange County Sheriff's Office?
Over 18 and a half years.
Okay. Has that all been sworn time, or were you?
Yes, let's double check those phones, please. Be sure they're silenced. If it goes off again, you'll have to surrender it to court security, and you can recover it when you leave the courtroom for the day.
Was that time all sworn with the Orange County Sheriff's Office?
It is, sir.
Okay. And how long have you been assigned to the FDLE task force focusing on audio and video enhancements?
Over 6.5 years.
Okay. And do you have any prior professional experience on audio and video enhancements prior to being part of this task force?
No, sir.
Okay. And can you give us a little bit of background on your education and anything that you've had in terms of specialized audio or video enhancement?
Yes, sir. I attended numerous classes and certifications in audio-video enhancements, the use of the equipment, even including the use of the equipment from the actual manufacturers. I attend training every year, so hundreds of hours.
Okay. And do you receive any certifications as a result of that training?
I do, and some of them is just regular advanced training on new procedures and modules.
Okay. And the certifications, are those for particular types of equipment that help you do your job?
Yes, sir.
Okay. In your time working with the Florida Department of Law Enforcement Task Force, do you know approximately how many audio or video enhancements you've done?
As of this year, well over 400.
Okay. And have those enhancements been admitted in criminal courts here in the state of Florida?
Yes, sir.
Have they ever not been admitted or been discredited in a court in the state of Florida?
Not that I know of.
Okay. What is the general process you follow when asked to enhance an audio or video recording?
The process is I received a hard copy of the evidence, whether on a USB or DVD. I then process the sample and depending on if it's a video enhancement, utilizing specific software for that type of source, digital source.
And in this particular case, what were you being asked to enhance?
I was given a body cam video and asked specifically to enhance a certain time period of the audio.
Okay. Do you do anything to avoid any sort of subjective interpretation or bias when you're getting this information in terms of what am I looking at here?
Yes, the information that I'm requesting is very generic. I'm asking for specific time periods that they want enhanced. I don't want to know any information about the case itself.
Okay. Do you also want to know whether or not, hey, we're listening for words X, or we think someone's saying something? Do you have that information?
No, sir.
Did you have that information in this particular case when you received the raw, footage?
No, sir.
Okay. Can you describe the software tools that you use in cases, and in particular what you used in this case to do the audio enhancement?
Yes, sir. I used a software known as AMP5, which is a video enhancement software. However, I used that software only to isolate the period of time that they were seeking the audio enhancement on. Once I scrubbed the video to just that specific period of time, I extracted the audio from that video, and using Isotope RX10, which is an audio software, audio enhancement software, I listened to the audio and made the enhancements from there.
Can you explain to the court how the Isotope RX10, how that enhances audio for you?
It pretty much works. I think the best explanation is it utilizes different filters, so we could either raise the volume on certain parts, lower the volume in other areas, like ambient noises, the wind that's around, try to reduce the wind so that way we could make discernible any speech and talk that's going on there. There's all different kinds of filters that we utilize, and it's kind of trial and error. We'll reduce it, bring it back up on the different filters so that way we could get the best clarity we can.
And in kind of describing these filters, like for instance, a wind may be what we call like a high frequency that may cover up the other audio that you're trying to listen to, something like that, is that correct?
That's correct.
Or ambient noise such as like birds chirping, things like that. You're trying to eliminate those high pitch to get to what you believe you're looking for?
Correct, sir.
Okay. All right. And can we talk, and have you previously used these tools to enhance audio on body-worn cameras?
Yes, sir.
Okay. Approximately how many times have you done this specific procedure?
Hundreds.
Okay. All right. And can you tell me what exact materials you received from FDLE and how were they labeled when you received them?
FDLE Pensacola sent me via FedEx a USB containing the body-worn camera video. From there, I brought it into my system, made a copy of it within the system, and then using AMP5, isolated the specific area, exported the audio only, and then using Isotope conducted the enhancement.
Okay. Did you also then increase once you did the enhancement, did you put it back together in kind of a short montage of both the body-worn camera unenhanced and then enhanced?
Yes, sir.
And in doing that on the enhanced portion, did you, other than putting it through the filters to get the clearest, was that the point of the filters, was to try and get the clearest, whatever was on that audio, make it as clear as possible for you to hear?
Yes, sir.
Okay. Once you did that and put it back on, did you also change anything with the volume level of that isolated audio clip?
No, the enhanced version that was attached to the video was how it was.
Okay. But did you increase the volume at all, or would that be labeled on the video that you did?
Yes, it will be labeled enhanced.
Okay. All right. And you also, I think, indicated that at this time you did not know what it is you are listening for. You've just been told, we want to see if you can hear something in a certain part of the body-worn camera. Is that correct?
I don't object for leading.
It is leading.
After you process the relevant audio, did you form any opinion as to whether or not anything could be heard on that clip?
Yeah, I'm going to object.
Without saying as to what, at this point, as to what we'll break it down, as to what was on that clip, was there any audio?
Yeah, I would object, refer to my motion limiting. I would also object to the witness giving any opinion.
I'll reserve a ruling.
And I don't know if this is, it sounds like this is an expert opinion. The witness was not listed as an expert, so I don't know I'm not even sure where we are at this point, if they're trying to elicit this as a lay opinion or an expert opinion. I'm not clear. Either way, I would object to the witness giving their opinion.
Response, Mr. Wood?
Your Honor, we can either, I mean, this was a state-provided witness. This is an FDLE witness. So we can proffer it either as an expert. I think he can be qualified as an expert with his experience and background. I think he's laid that criteria. The state was present for a deposition. It is the state's witness that we supplemented back to them, so I don't know what the harm is on that part, but.
Surrender the phone, please, and you carry it outside. Whose phone went off, please? All right. Just carry it outside. You can recover it when you leave the courtroom for the day, okay?
Your Honor, in terms of the proffer, I believe he can be both a layperson who has performed work on a product, which then can be potentially interpreted by the court. I also think that he could be qualified as an expert in doing so as well. And so I think in terms of my proffer, it would probably be as both, and then the court could decide whether or not one or both is an admissible avenue.
I'll reserve ruling.
And on that particular issue, have you previously been qualified as an expert in producing and enhancing audio in the state of Florida?
No, sir.
Okay. But your enhancements have been accepted, is that correct?
Yes, sir.
Okay. All right. Was the audio ever outside of your presence manipulated by anyone else to your knowledge?
No, sir.
Okay. And when it came to you, was it explained to you, was there any evidence of that this was the raw footage from the body-worn camera? How did you know that?
Just based on the information that was sent to me, that they were sending me an original copy.
Okay. And how do you receive that? Does that come directly from FDLE or from another
Correct.
source?
FDLE.
Okay. Did you keep any copies of the enhanced audio or the data after you did your analysis and enhancement?
No, sir.
When you did the enhancement, were there portions that you were asked to look at that remained, in your opinion, inaudible, that you couldn't hear or decipher anything of relevance?
Yes, sir.
Okay. Were there portions of it that you believed were audio that could be deciphered?
Yes, sir.
Okay. And the state will make an objection here, but were you, once again, did you have any idea what you were listening for?
No, sir.
And did you form an opinion as to what you heard on that enhanced audio?
Yes,
Got
sir.
I would object or refer to my motion limine and also the witness giving an opinion.
Reserve ruling.
And what was your opinion as to whether or not there was anything audible in that section that you isolated?
There was.
And was that audible? Were those sounds, words? What did you believe them to be?
Words.
And what words did you hear?
I would renew my objection for the same reason.
Reserve ruling.
Yes, Your Honor.
You can answer the question.
What I surmised was being said, "Oh, fuck, police."
When you took that audio, you then put that, after you'd isolated it, did you put that back into a video?
Yes, sir.
And did you put that into a video clip, as we talked about earlier, that's the body-worn camera, both the original and then immediately attached to it and playing after is the enhanced with repeating the enhanced form of the audio, is that correct?
That's correct.
And you produced that?
Say again?
You produced that?
Yes, sir.
That, we'll call it a video clip, is that accurate as to what it is?
Yes, sir.
And does that fairly and accurately depict the enhancement that you created through the filters of the, I believe it's the isotope RX10, is that correct?
Correct.
Okay. Did you provide that enhanced audio clip and original clip back to the Florida Department of Law Enforcement?
I did.
Okay. All right. Your Honor, I don't know if you want me to approach the witness and play the clip to make sure that he recognizes it, but at this time I would be asking him to take a look at that and then potentially admit that as Defense Exhibit 1.
Your Honor, I mean, assuming that's what it is, I don't have any objection as to the foundation. I do have an objection as to the admissibility. This was not specific, well, I didn't file a motion limine specifically as to the video. My objection to the video is that, again, we're talking about the perceptions of Eddie Duran as he stands there outside the door, enhancing the video and improving the quality. He does not have that ability. So I believe that would create a very misleading effect for the jury, that they may be able to hear better than he is as he's standing there. So I believe we have the original, and that is the most accurate copy. So that is my basis of my objection to the video itself.
Reserve ruling.
Yes, sir.
Your Honor, in just brief response so that I can also make a record, I believe that not knowing where the court will end up on this, that you have a challenge to whether or not Deputy Duran heard this. I think if there's a video that enhances that allows the court a peer into a deeper understanding of what was on this audio, given the fact that it is something clearly heard, picked up by a body-worn camera, which obviously is not, I would say, common sense, not as sensitive as to the deputy's individual ears. I think it assists the jury in that process. But I understand the court's ruling in terms of reserving that. But at this time, Your Honor, I would ask if I could publish this. Once again, this does have the body-worn camera portion right up to, and does include the audible, and before it cuts to the enhanced version, there is an audible shot fired. So I know that that may be something I want to let the gallery know, that if that was going to be published, that would be something that they may not want to see.
Is it necessary to publish the whole thing, or can we just see the enhanced
I can
portion?
move it forward to the enhanced side and then plug in my computer for that enhanced portion, Your Honor. I'm fine with
Isn't
that.
that the focus of this interrogation and this witness?
Yes, I'll just do that part, Your
All
Honor.
right, we'll have the witness identify it for the purpose of the evidence issues, subject to the state's objection. And let's just publish the portion which is the emphasis of this case, of this witness's labors here.
May I approach the witness, Your Honor?
Granted.
Your Honor, may I just briefly approach?
Yes, sir, you can look over his shoulder. see
Yes,
what's
and
going
it's,
on.
I believe it's what we sent and discovered, so.
Yes, sir, go ahead.
Your Honor, may I approach for just one moment?
Granted. Yes, sir, go ahead.
Yes, sir.
May I continue, Your Honor?
Your Honor, again, I have no objection as to the foundation of what the video purports to be.
And just so that we make a record, Detective Hernandez, you did get a chance to review. Is that the video that you produced?
It is.
Okay.
And we're only really going to see we're only concerned at this stage of the proceeding with the audio that has been enhanced.
Okay. Because it's attached to the video, I will move past the original audio in the video. There will be, but I will stop it after the enhancement has been replayed.
Well, I think that's important because we have our videographer.
Yes.
And the videographer's asking whether he should cut his video because we don't want to present that portion public.
I'm going to capture just the audio, no
Okay.
video.
Okay, very good. Thank you, Ken. Tell me when you're ready. And you're in 2B?
I am. Give me 1 minute here.
All right, yes, sir. Just let me know when you're ready.
I'm sorry.
Yes. 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 I'm just going to make sure I have it correct before I plug it in, Your Honor.
Yes, sir. Granted.
Mr. Rutherford, that will need to be in the envelope, per my supervisor.
Say again?
It will need we can't just have a loose, something, Your Honor, that will need to, envelope of some
That's
sort.
correct.
There's some writing on this, but all right,
He has two.
And that's defense what?
the exhibit one, Your Honor.
One?
Yes.
Or-
Yes, Your Honor.
Well, we're going to make a bad record if the defense and the state are both using numbers. Can we use letters, please?
We'll use A, please, Your
We'll
Honor.
use A.
All right. So it's defense A. And it's admitted subject to the state's continuing objections. Well, no. I'm going to take it into evidence for ID only until the court rules on the motion and objections.
Yes, Your
So,
Honor.
Madam Clerk, defense A, ID only.
Yes, Your Honor.
Your Honor, with that, I would tend to the witness.
Mr. Alden.
Good afternoon, Detective.
Good afternoon.
Sir, you've never previously testified as an expert anywhere, have you?
Excuse me?
You've never previously been qualified or testified as an expert, correct?
No, sir.
And the software tools that you use to reduce the volume of some things, enhance the volume of others, obviously the human ear does not have the ability to do that, correct?
I'm sorry, I don't understand the question.
So you use software you described to turn down the volume of certain items, turn up the volume of others, correct?
Correct.
The human ear does not have that ability, correct?
Correct.
And you testified as to what you thought you heard, but you're not sure what you heard, correct?
In regards to what I heard,
Yes.
that's what I was able to discern.
Okay. But it's open, you'd agree it's open to interpretation, correct?
It could be.
Okay. It is interpretation, correct?
Correct.
And that's your interpretation, correct?
Correct.
And it could have been something else?
Not from what I heard, sir.
Okay. But that's your opinion as to what you heard, correct?
That's what I heard.
And it was a statement to that effect, correct?
Correct.
Okay. Could it have been a question?
No, it sounded more like a statement.
Okay. But again, that's open to interpretation, correct?
That's what I heard.
Okay. But is that open to interpretation?
It is.
Okay. Thank you, sir. And Judge, I don't know, I'm sorry, I'll let.
All right, redirect.
No, Your Honor. We'd excuse the witness at this
All
time.
right, the witness excused. Mr. Alderman?
Yes, sir. Sorry, let me get back to the microphone. I don't know if I explicitly put it in the motion, but part of my objection to the testimony from Deputy Hernandez is human nature is that when somebody tells somebody, this is what I heard, the inclination is to listen for that. And the way human ear works, if you listen for something, you can hear it. As Deputy Hernandez said, when he listens to it blind, so that he doesn't suffer that. But so for a jury to tell them this is what we heard, then they listen for that. That's my issue with him giving that interpretation, that the jury should have the benefit that he had in listening to it blind, and they can make up their own minds.
Reserve ruling.
Yes, sir. Thank you, sir.
Deputy, have a safe journey home.
All right, thank you, sir.
Good day. Next witness, please.
Your Honor, defense would call Mossad Ayub.
Old prosecutors do it frequently. I've done tobacco cases, the state would call it. He was not sworn.
You raise your right hand, please. Madam Clerk, will you swear the witness?
Do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Please be seated.
Thank you.
and direct your voice to the microphone you see there in front of you and speak clearly and distinctly for us so we can all hear and understand you, and also the court reporter is able to make a good record, okay?
I'll do my best, Your Honor.
All right, and if one of these lawyers objects, then stop speaking until I give you an instruction on how to proceed.
Understood.
Mr. Whitaker.
Thank you, Your Honor. If you could please state your name and spell it for the record.
Certainly. Masad Ayub. The first name is spelled M-A-S-S-A-D. Last name A-Y-O-O-B.
And can you tell the court what your, obviously you have not been qualified at this time, but what your anticipated area of expertise testimony would be today?
Dynamics of violent encounters, use of force policies and procedures, training standards for law enforcement use of deadly force, excuse me, and investigative elements of officer-involved shootings.
Okay. Can you briefly describe your current professional role?
My current?
Current. Yeah, what you're doing right now, what your business, what you do now.
Certainly. I run a school called Masad Ayub Group. We teach around the country, primarily judicious use of lethal force in defense of self and others.
How long have you been the director of the Masad Ayub Group?
Since 2009.
Prior to that, did you direct any other training organizations?
Yes, I ran a similar training entity, Lethal Force Institute, from 1981 to 2009.
Okay, and what is the Lethal Force Institute, or what was the Lethal Force Institute?
Like Masad Ayub Group, it's a training entity focusing on judicious use of lethal force in defense of self or other innocent parties.
Okay. And you also previously were a law enforcement officer, is that correct?
I was.
And can you highlight your service as a law enforcement officer, including the years that you served?
Yes, 1972 through 1980, a patrolman with the Hooksett, New Hampshire Police Department. That's Hookset. 1982 to 1990, 2 years as sergeant, 6 as lieutenant for the Deerfield, New Hampshire Police Department. Excuse me, and 1990 to my retirement in 2017, a captain with the Grantham, New Hampshire Police Department, throughout a use of force instructor.
And your total years in law enforcement?
Approximately 43.
Okay, I want to change direction a little bit on just general education and training. What's your formal education?
Formal education is a bachelor's degree in business science.
Have you had any representative or advanced training relevant to firearms tactics or investigations?
Yes, extensively. Firearms and tactics from the early 1970s on. In homicide investigation, I graduated the medico-legal death investigation course, excuse me, taught by the Metro-Dade Medical Examiner's Office in Miami. Basic and advanced officer-involved shooting investigation courses at Los Angeles, taught by the Los Angeles Police Department. Advanced homicide investigation, taught by Vernon Geberth, Geberth, the author of a primary text in the field, Fundamentals of Homicide Investigation, or Practical Homicide Investigation. Twice through the International Homicide Investigators Seminars, and in both of those was also one of the guest lecturers. Numerous shorter courses on officer-involved shooting investigation or elements of homicide investigation.
Have you ever served as an instructor or faculty in a professional setting in law enforcement, training, or use of force?
I have, for a period in the 1970s, I was assistant professor teaching weapons and chemical agents for the Advanced Police Training Program of New Hampshire at the Nashua, New Hampshire Vocational Technical College. Excuse me. I spent 19 years as chair of the Firearms Deadly Force Training Committee for the American Society of Law Enforcement Trainers, and spoke at almost all of their annual seminars.
And what is the purpose and goal of the Association of Law Enforcement Trainers?
Well, their goal was advanced training for instructors in everything from adult education principles to the various specialties, investigation, use of weapons, use of force, emergency driving, emergency medicine, and related topics across the board.
And your focus with, and we'll call it, is it ASLET? Is that how you?
Yes.
Okay, what was your focus? What did you bring to the table to ASLET?
Primarily weapons and current deadly force policies at the instructor level, basically training the trainers.
Have you held any leadership or advisory roles with professional training associations?
Yes, in addition to ASLET, I've been on the advisory board of the International Law Enforcement Educators and Trainers Association, ILETA, since its founding in the early 2000s and remain in that position.
And so you have taught for both the International Association of Law Enforcement Firearm Instructions and for the International Law Enforcement Educating Trainers and Trainers Association.
Correct.
Okay. Have you authored any relevant books in this field?
Approximately 20 books related to weapons and various forms of self-defense. Excuse me, on just deadly force. Two of them would be In the Gravest Extreme, published in 1980, and Deadly Force, first edition, published 2014, second and current edition, 2022.
Have you published any articles in professional journals or periodical journals related to law enforcement and self-defense?
Yes.
Approximately how many times?
Well, it would be, law enforcement journals would be in the hundreds, counting gun magazines and martial arts magazines, it would be in the thousands.
Have you also produced or been, I guess, the person appearing in YouTube videos regarding self-defense and issues related to that?
Yes, I was a regular on Personal Defense TV on the Sportsman Channel. Excuse me. Did a few for the Make Ready production group, Panteo Productions, P-A-N-T-E-A-O. Numerous videos on the Wilson Combat Channel and my own channel now, Facts and Firearms.
Okay. Did you ever hold any editorial roles with firearm or law enforcement publications?
Yes, I was, excuse me. I was a feature editor for a series of law enforcement professional journals, Trooper, Patrolman, and Sentinel. Handgun editor for Guns magazine from late 1970s to when they ceased print this past year. Law enforcement editor for American Handgunner magazine from their founding in 1976, I believe, to them going out of print last year. I did the off-duty column and the first responder column for a magazine called Guns and Weapons for Law Enforcement, and did the the self-defense and the law column for Combat Handguns magazine.
Have you provided sworn testimony as an expert in criminal and civil matters?
I have, sir, since 1979.
And do you have an approximation as to how many cases that you've been involved in?
No, involvement in terms of consulting would be in the hundreds. Sworn testimony, probably still under 100, hopefully.
Okay. And in those sworn testimony, were you qualified as an expert in self-defense, in issues related to use of force dynamics, issues of relevance in this matter?
Then self-defense training standards, yes. Dynamics of violent encounters, investigative protocols, shooting reconstruction, that sort of thing.
Okay. And how long have you been being qualified as an expert? For how many years?
That's my 47th year now, I guess.
And you've also been involved in several cases, including manslaughter or wrongful death, is that correct?
Yes.
Okay. Any of those cases involve Florida criminal actions?
Involve what?
Actions that were in Florida, criminal actions, criminal prosecutions that were in Florida?
Yes, Florida versus Luis Alvarez in Miami, Florida versus Ed Michael in Orlando. For law enforcement shootings, those are the ones that come to mind.
And were those as a defense or a state witness?
Those are for defense.
Have you ever been a state witness?
I have.
Okay. How often does that occur?
Rarely. The prosecution normally doesn't need to hire an outside expert in my field. They can simply request an expert from the local police academy or local police department.
Okay. So somebody within the agency who's qualified?
Within the agency or within local law enforcement circles.
Okay. How did you become involved in this case?
You contacted me in 2024.
Okay. And did you immediately take the case, or what was your procedures in assessing and determining whether or not you would be willing to be a witness?
I never immediately take a case. I always require full discovery beforehand. I charge 1 day to review discovery. If I'm not comfortable with the case, I'll explain why, and I generally turn down more than I take. If I'm comfortable with the case and I feel I can be of help, we go from there.
Okay. And initially to do that review, you charged to do that review, is that correct?
I charge the same as I charge to teach, $3,000 a day in expenses.
Okay. And what is your hourly rate?
That divided by 8 hours, that's $375 an hour.
Okay. And do you know how much you've been paid by our firm and your representation?
It's a little over $8,500 counting expenses.
Okay. Can you identify the materials that you reviewed prior to forming any opinions in this matter?
What was represented to me to be a complete discovery package of the materials furnished by the state to the defense, what the defense in turn had furnished to the state. The deputy's personnel file, including training file, the autopsy protocols, the depositions of the various witnesses, the officer's Garrity statement. In addition to that, I went to the scene and with you and also interviewed the defendant.
Your Honor, may I approach briefly?
Granted.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Your objection's noted for the record, and once again, there's no jury present, so we'll just proceed accordingly.
And, Mr. Ayoub, did you prepare a written report in this matter?
I was not asked to, nor did I.
Okay. Can you describe the framework that you apply when you're analyzing police use of force incidents?
We have to look at the totality of the circumstances, what led up to it, who saw what or heard what, were they where they could see or hear whatever is under discussion, and how it all fits into policy and, predictable action-reaction times, things of that nature.
And are you familiar with, in your training and experience, and the work that you've done with police training standards on the use of force?
I am.
What about the dynamics of violent encounters and as a law enforcement officer?
Yes, it's been something I've taught since the beginning as a firearms instructor since 1972. Excuse me.
Your Honor, I'd pause for a moment and see if Mr. Alderman has any additional questions of Wadu that you'd like to ask at this time.
No questions in that regard, no, sir.
You may proceed.
Can you explain action versus reaction as it pertains to drawn versus a holstered firearm?
Well, certainly, it's a general rule, action beats reaction. The person who moves first has a significant advantage. The drawn gun against the holstered weapon it's as if you had an automobile race where one vehicle was already well in motion and gaining momentum, and the other had not yet been put into gear. The drawn gun has only to be indexed, that is, aimed or pointed at that which is to be shot. To draw the gun, one has to get the hand, it breaks down into what I would call access and presentation. The hand has to get to the gun. In the case of a uniformed police officer, you have to defeat multiple retention devices that are made to make the holster snatch resistant so no one can snatch the officer's gun from its holster. You've then got to rock the gun muzzle up and bring it to the target. Against the drawn gun, if the gun is down in a low ready position pointed at the ground near or in front of either party, all they have to do is simply raise the pistol and pull the trigger.
And you've had an opportunity to review not only the discovery materials in this case, but also the body-worn camera, is that correct?
I have.
And the opinions that you're going to be asked about, are those based on your education, training, experience, coupled with that review of the relevant documentation?
Yes, all of the above.
Taking you to the incident in May of 2024 involving Deputy Duran and Airman Fortson, you already kind of described the gun being at a low ready. Was that something that the discovery materials, is that an opinion or a fact in your mind?
Oh, that's a fact. You can simply look at the video. A low ready position, the gun is drawn, the muzzle is down, the hand has a firing grasp with everything but the finger on the trigger, and basically all the shooter has to do is raise the gun and bring the finger to the trigger to shoot.
And what is a low ready? What does that mean?
May I stand to demonstrate?
You can, but also then describe when you sit back down, ready for what?
Certainly. As I'm standing here, a ready position could be two-handed or, as on the body cam video, one-handed. The gun can be down here at the side the arm appears to be slightly flexed on the body cam at an angle approximately like this. If I'm facing another person on the same level, I have only to lift the hand and bring the finger to the trigger at the same moment.
I'm going to change directions for just a second here. In reviewing the body cam and the discovery in this case, did you have an opinion as to Duran's decision to not wait for backup to go to apartment 1401?
I have an opinion. I do not believe backup would have changed anything. Anyone on Mr. Fortson's side of the door would not have been able to see how many officers were there, so the presence of a second or even third officer would have no intimidation effect.
And in this case, did you believe the information that was provided to Deputy Duran that constituted a physical disturbance involving a male and female? In your experience, training, and education that you provided, would you consider that domestic in relation, in nature, or some other kind of?
No, that's classic domestic.
Okay, and why is that?
Police well know it's one of the most dangerous situations for them to enter. The people are already becoming combative. Emotions at the scene are running in a high pitch. Inside a home, every kitchen is full of knives, cleavers, etc., that could be weapons. And in many homes, particularly Florida, there are firearms. So put all that together, it becomes a potentially dangerous environment in policing anywhere. With the institutional history of this particular agency, in less than 20 years prior to the incident, all 5 Okaloosa County deputies who were murdered in the line of duty, those situations had begun in some way as domestic violence.
And are you aware in your discussions with anyone, including the defendant, or through reviewing his records, whether or not Deputy Duran was aware of that information?
He was aware.
Your Honor, I would object. That explicitly calls for inadmissible self-serving hearsay.
Ruling is reserved.
The manner in which Airman Fortson is holding that pistol, is that you've indicated that was at a low ready, is that correct?
Correct.
Is there a way to hold a pistol that is not in a threatening or what we call a ready position?
There are, do you have a dummy gun or a neutered evidence gun that I can demonstrate that with?
Yes, Your Honor, I do have, the bailiffs are aware of it, and we did bring it in. We have a rubber fake gun, if I can approach a witness with that.
I'll be sure that my bailiff has had the opportunity to examine and confirm.
They have.
Thank you.
May I approach the witness, Your Honor?
That goes back to one of my very first trials, where Exhibit 1 was the firearm and Exhibit 2 was the loaded magazine, which was handed directly to the witness. So from now on, every time anyone mentions anything about it, the bailiffs are responsible for being certain that everything's safe.
Understood, Your Honor.
You may approach.
Okay, may I stand to demonstrate?
You may, sir.
Okay, I have here what's called a Rings dummy gun, RING''S, the name of the manufacturer. It's a dummy of a Glock 17, which in turn is the same as Mr. Fortson's Glock 47, except the barrel and slide would be half an inch longer. Standing here, finger off trigger, I recall Mr. Fortson in the video standing with the elbow slightly bent and the gun muzzle pointed downward. This is a firing grasp, and in an instant becomes a firing position once the hand is raised. It would take somewhere around a quarter second. Someone very young and fast might be able to do it faster. If I was to hold this gun in a less threatening position, all I have to do, it's in my right hand, take my thumb from the left side of the gun and bring it around to the right side and grasp it as I'm demonstrating here. The dorsal part, the back of my hand, is covering the trigger and trigger guard area on the right. My fingers are covering the trigger and trigger guard area on the left and are not in a position where they can touch the trigger, bring it to the rear, and cause the weapon to discharge. Alternatively, if I had a door that was opening inward toward myself, let's say with the hinge on my left, I could place the gun in my other hand with the palm down on top of the slide as I'm demonstrating here. That would put it in a grasp similar to someone holding a hammer about to pound a nail. But now just the back of the gun would be presented to anyone I was facing, and it would be much less threatening. The barrel of the gun and the muzzle would now be pointed behind me into what we now know was an empty apartment. And it is a much less threatening grasp. Finally, looking at the diagrams of the apartment layout and the video, it appears that Mr. Fortson was within a step of a kitchen counter that would have been to his right and could have simply set the gun on the counter and then opened the door.
In your review of Duran's training documents, was he trained on the dangers of someone presenting with a gun at the low ready?
It's my understanding that he was in basically every department that he served.
Do you believe that it's within the common understanding of the community, the rapid rate at which, or the immediacy of which somebody who has a gun at the low ready can fire a lethal shot?
Actually, no. One element of this is unfortunately it's subjected to a lot of myth and misunderstanding. Violence seems to pervade American entertainment media, and you see the shooting scenes, for example, happening in literally slow motion. Some of the action movie directors call it the slow dance on the killing ground. It creates the illusion that these things happen with much more time for someone to consider alternatives or retreat or attempt to de-escalate. One thing you have to do is constantly come back to the unforgiving speed at which this happens. I would expect a shot to be fired in a quarter of a second. In my interview with Duran, he said he had been taught that in law enforcement.
I would object again. Again, that's explicit hearsay.
Reserve ruling is reserved.
Yes, sir.
You may proceed.
In your review of materials in your interview with Duran, was he aware of the danger that you've just discussed and the immediacy of being potentially shot with somebody with a gun at low ready?
He was.
Yeah, again, I would object for calls for hearsay.
Ruling is reserved.
In the course of you assisting us, were you asked to produce any demonstrative aids in regards to the issues that we're talking about?
I was.
And did you produce any videos?
I did.
Can you tell me about the first video that you produced?
The first video was to answer your question, how rapidly could someone from that one-handed low-ready position bring the gun up and shoot a police officer standing approximately 4 feet from them. I did that with an electronic gunshot timer, excuse me, starting with a Glock Model 47 pistol and live ammunition held in the position I described and demonstrated earlier, mimicking what was on the body cam. When I heard the beep of the timer, which indicated the timing had begun, I raised the gun and fired. The concussion of the gunshot registered on the timer. Now, that had required me to react to a signal which would not have been the case with someone with a gun initiating their movement. So to remove my reaction time, I tested my own reaction time on the device by turning the readout away from me so I couldn't, jump the gun, as it were. And when it beeped, I slapped it. I believe my reaction time that day was 23/100ths of a second, which is in the ballpark for average adult human, around a quarter second. So with that factored out, the speed for a shot to the body fired from below line of sight was just over a quarter second, 29/100ths. The second thing I wanted to demonstrate was if the officer was wearing body armor, which I would expect he would be, and it would be visible to an opponent who, if they wanted to shoot him, would probably try to shoot him in the unprotected head. To determine how fast the gun could be raised from that position for an aimed headshot, we did the same thing again, and that turned out to be just over half a second, I believe 56/100ths of a second.
Do you believe that demonstrative video is relevant to the facts in this case?
I absolutely do.
Why?
It's fundamental to understand the speed at which this happens. From the first telling of it, it takes longer to explain what happened than it took for the thing itself to occur. And it creates that false illusion of slow motion and all sorts of time for the defendant to have considered other alternatives or initiated a conversation or tried to take the other person at gunpoint in order him to draw the gun. None of which, when you look at the actual speed of encounter, would have been viable.
Is that something over the course of the many years that you've been involved in this industry that you have trained nationally in regards to?
It is, and it is very widely understood among police instructors and the law enforcement community.
And in your review of the records and the training records of Eddie Duran, was that something that he was instructed on?
It's my understanding that it was.
Okay. Does that video fairly and accurately demonstrate how quickly someone at the low ready can fire?
I believe it does.
Okay. One caveat here, not trying to do age discrimination, but how old were you when you produced that video?
I did that video in January 2025. I would have been 76.
Okay.
And I should mention arthritic with the fingers kind of twisted and about half the hand strength I had when I was Duran's age.
That being said, though, you have had extensive firearm experience. You don't question that at all, is that right?
Oh, I have. The point is, you don't need extensive firearms training to raise a pistol and pull a trigger at 4 feet.
Would the video assist you if this were to be published to the court?
Repeat, please.
Would this video assist your testimony if it was published to the court and provided to the court?
It certainly would.
Okay. If I can, Your Honor, once again, go through the procedure approaching him. I know you've seen the video, but go through that, and then if the state has any objection, and then, like I said, it is a live fire demonstration against a paper target, but there is a real gunshot that does occur in the demonstration. I want to let the court know.
I remember it was two separate.
They're two separate. This is just the first one at this time.
Your Honor, assuming it's what I've been sent, again, I don't have any objection as to the foundation. I do have an objection based, referring back to my motion to eliminate as to the relevance, and that process has now just been thoroughly described. And as Mr. Ayub just said, raising that arm, the visual demonstration, I believe, has a terrible connotation for when the jury is considering what happened or what might have happened.
Ruling is reserved.
Yes, sir.
And I believe, if I'm not mistaken, the defense, with the consent of the state, provided these videos to me in advance to be prepared for the motions in limine, correct?
Yeah, well, I know they were attached to what the defense said.
So these are the same ones you previously provided, Mr.
They are, Your Honor.
Okay.
May I approach?
Granted. Mr. Alderman, if you wish to stand over and be certain that the evidentiary foundation is correct.
What I made of what will allow Mr. Alderman, okay, showing both videos, so I can back and forth.
Yes, sir, that's fine. Lay your foundation.
Yes, sir, that is the video we've been discussing.
And was about 5 minutes in length, 4 minutes, 50 minutes?
4.5 to 5.5 minutes, I think.
Mr. Ray, we had an opportunity to show you two videos, one about 4 minutes and 59 seconds in length, and the other just over 3 minutes in length. Did you recognize both of those videos?
I did.
Are those the videos that you produced and shot?
Correct.
Okay. No, I'm sorry, I didn't mean to use the word shot, but that you videotaped.
Caused to be produced.
Yes. And those fairly and accurately are what you have described initially as number one, and we'll get to number two in just a second. Is that correct?
Well, the number two was one that you requested.
We're going to do with one right now, and then I'll talk about number two.
Okay.
So we'll say for number one to start with. Is that correct?
Yes.
Okay. All right. And I'll go ahead and qualify the other one, Your Honor, and then we'll just do it at one time, if that's all right with the court and the state.
I'm sorry, I didn't catch that one.
I was going to just go ahead and start having discussed number two rather than pausing and publishing and redoing.
Yes, go ahead.
Okay. Do you recall being asked some questions that raised the production of the second video?
Yes.
And what was the nature of the discussions that were had?
That Mr. Duran's critics had suggested that he should have drawn his gun and taken Mr. Fortson at gunpoint and ordered him to drop his Glock. And this was to explain why that would be a futile strategy. It would end up as what the old cowboy movies used to call a Mexican standoff, two men pointing guns at each other, and now each telling the other to drop their weapon. And now whichever pulls the trigger first is going to prevail and presumably kill the other one.
In this particular scenario that you did, were two people pointing the gun at one another, or was one person pointing at a person with the gun at low ready?
I and the other role player, Christopher Lamb, L-A-M-B, a retired Colorado State Trooper, took turns playing each role, the person in Mr. Fortson's position and the person in then Deputy Duran's position. With the person in Fortson's position holding the gun down, as I've demonstrated earlier, and as you've seen on the body cam, each of us were wearing protective gear, and we were using what's called simunitions. It's basically functional Glock pistols, which have been built so they can't shoot live ammunition, but instead they shoot a sophisticated, powerful paintball driven by a small charge of gunpowder that will mark the person or the target that it's hit. We found each time, with one of us in the role of an officer taking the other person at gunpoint, that the person with the gun down, as Mr. Fortson was holding it, could raise the gun and shoot the person in the officer's position before the person in the officer's position could react and pull the trigger of their already aimed gun. Again, action beats reaction.
And does that fairly and accurately demonstrate the continued lethal threat a gun at low ready presents, even if you have someone at gunpoint?
Yes, you're basically somewhere between a quarter a second and a half a second away from being shot at the other person's will.
And would it assist you in explaining, or assist you in your testimony, if that video were to be published, and words are sometimes better, video is sometimes better than the words? Is that accurate? Sometimes.
Yes, very, very true.
And this dynamic, is this something also in your review of the discovery that Deputy Duran would be aware of and had been trained on?
Yes.
Okay. Your Honor, with that, I would ask to publish these two videos to Your Honor.
Your Honor, again, I would renew my objections to both videos based largely on the motion of limine that I filed. What I don't think I mentioned in the motion of limine as to the second video is the visual bolstering of the defendant's testimony in terms of the second demonstration where the firearm is initially presented.
Ruling is reserved.
Yes, sir.
Your Honor, I should be ready on 2B.
And just as a reminder, I believe there's a connection at the lectern if it would be more comfortable.
That's fine.
We can say, yeah.
That worked.
You're live. Sound.
My name is Nassad Ayub. I've been retained as an expert witness by defense counsel in the case of State of Florida versus Eddie Correa. We're on my shooting range in Live Oak, Florida today to demonstratively answer a question by defense counsel, that being, if one man is holding a pistol down to his side, muzzle toward the floor, how quickly could he raise that gun and shoot another person standing perhaps 4 feet away? We'll attempt to demonstrate that now. This is a B-21E police silhouette target. It's the standard one used by most, if not all, Florida law enforcement agencies for qualification. Defense theory is that when Duran reacted and went for his gun, the two men were about 4 feet apart. So we've roughly duplicated that with a 3-foot yardstick and a 12-inch foot. The pistol Mr. Fortune was armed with was a Glock 45. To avoid confusion, 45 is not the caliber, it's the model number of the pistol. It's actually a 9mm pistol, basically a popular service pistol. Comes with a standard 17-round magazine, such as the one found in Fortner's gun. I'm going to start with my hand, holding the pistol down my side, and I'll react to an electronic start signal. When I hear the beep of the start signal, I'll fire. The device is a packed-brand PACT electronic gunshot timer. The way it works, when you press the go button, is set for a 3-second countdown, at which time there will be a beep sound to signal it's time to shoot or time to do whatever you're testing. Now, when the sensor feels the concussion of a gunshot wound, replicated here with a slap, it'll stop the time. In this case, it was 4.71 seconds from when the signal emitted to when I slapped. Now, one of the things we have to deal with here is I'm reacting to that start signal, which adds reaction time. What we're trying to test for is how quickly a person self-initiated with no reaction time could raise the gun and shoot. So we'll have to subtract my reaction time from the total time. To determine my reaction time, I'm going to turn this away so I can't anticipate the exact instant of the beep. I'll hold my hand over it, and when it beeps, I'll slap. And we have 0.23. Typical reaction time in a Belgian is right around there, 0.23, 0.25. We'll load the pistol. I'm standing with my torso level at the 4-foot mark. I'll start with my finger off the tip of the pistol. We have a shot dead center on the chest at 0.52, 52/100ths of a second. Now we determined my reaction time was 0.23. We'll subtract that from 0.52 total. And basically we have 0.29, 29/100ths of a second. Less than a third of a second, slightly over a quarter second. Well, the question might be asked, if the officer is wearing body armor, would that not have saved his life? Probably would have, but particularly if the body armor was visible, if the opponent shot with the unaffected head, the outcome would be ugly. So what we're going to do is go for the head here. That will take more time because the gun has to rise farther, and aim has to be more precise because the head is a smaller target than the torso. Shot to the head at 0.79 seconds, slightly over 3/4 of a second total. We'll need to subtract that reaction time. So we have raise the pistol and fire the fatal shot. I believe that will conclude the demonstration.
Wait a second.
It's April 14, 2026. My name is Masad Ayub. I'm advocated as an expert witness by the Defense Council in the case of the state of Florida versus Duran. Assisting me today is Gerald Christopher Lamb. We're here to demonstratively answer a question by the Defense Council. That question being, if a police officer is facing a man who has a Glock pistol down his side, as I'm demonstrating here, would he be able to successfully draw his own service pistol, take the man at gunpoint, and order him to drop the gun? And if so, what dynamics now would be in play? To demonstrate that now is what's called simunitions. Simunitions are essentially high-tech, powerful paintball. The pistol is a Glock 17T, manufactured by the same company that manufactured the late Mr. Forson's Glock pistol. And his Glock Model 45 9mm would be functionally identical in size, shape, and 5.5-pound factory-installed trigger pull. The simunitions are used in what's called police training force-on-force, essentially live-action crisis role-play, where instead of shooting at a target or a piece of cardboard, the officer is up against a living, thinking, reacting human being who will try to hurt him. These will hurt and draw blood. There have been cases of injuries with them. You can see that one right through the